Good afternoon, ladies and gentlemen. Welcome to this joint seminar by the Center for Comparative and Public Law and the Department of Politics and Public Administration. Today, we're very honored to have Professor David Law, Professor of Law and Professor of Political Science from Washington University, to speak to us on constitutional archetypes. David earned his PhD in political science from Stanford University, the BCL from Oxford, and the JD from Harvard. You must be the dream kid of every parent in Hong Kong. His research has been supported by the National Science Foundation, the Council on Foreign Relations, and the Fulbright Scholar Program. His works appear in leading U.S. law journals. He's held visiting positions at various leading law schools in Japan, Korea, Taiwan, and the U.S. Let's welcome David.
Thank you, Cora, for that very generous introduction, which I don't quite deserve. I'm sure it'd been news to my parents that I'm a dream child, but I'll let them know. So this paper arises partly from it's part of a larger book project on whether there are patterns to constitutionalism, and if so, what those patterns are. And let me review some of the hypotheses that are out there now. One is a convergence hypothesis, that constitutions are becoming increasingly similar. I want to be clear that today I'll be talking just about constitutional drafting. The larger book project will address both drafting and adjudication, but today I'll just be talking about patterns in constitutional drafting. Some people say, for example, that globalization and related factors may be promoting constitutional convergence, and there are certainly signs of convergence when we look at some aspects of constitutions. For example, most constitutions contain something like a Bill of Rights, and moreover, there is a fairly standard set of rights that appear in the vast majority of constitutions. So there is some evidence in favor of the convergence thesis. There is also what might be called a fragmentation thesis, which will be familiar to people in the field of comparative law. Montesquieu argued that while there are transnational patterns in private law, there is no such thing when it comes to public law, that constitutions necessarily do and should reflect local circumstances and local conditions. And so it is not possible, argued Montesquieu, nor is it desirable to engage in constitutional borrowing from other jurisdictions. And so while there's a lot of literature on the possibility of convergence in private law scholars, generally, comparative law as a field has been very reluctant to make claims about convergence when it comes to constitutional law. A third hypothesis, I guess I would call the bricolage hypothesis. This is a term that is borrowed from Claude Lévi-Strauss, and it is a somewhat postmodern understanding of how constitutional drafting works. The idea here is that constitution makers mix and match from whatever parts are available. I'll say more about that in a moment. Günter Frankenberg is known for, he has a particular version of this theory called the IKEA theory, and Mark Tushnet has also described this approach. And finally, there is an idea which I think will be familiar to people from the comparative law literature, but not the comparative constitutional law literature. What's interesting is that there is a very sharp divide between the theories proposed in comparative law and the theories proposed in comparative constitutional law. The competing models view is that there are competing families or legal traditions, if you will, and the world can be broken down into. So, for example, the divide between civil law tradition and the common law tradition is a go-to of the comparative law literature. And it may well be the case that the same could be said of constitution making. However, that argument generally has not been made of constitution making. Again, if we look at the comparative law literature, the standard view is that it is impossible to generalize across constitutions for the reasons Montesquieu gave. Constitutions, public law, are necessarily rooted in their context. So what do I mean by the bricolage thesis? Some of you may recognize this. Anyone here recognize this? This is what is this? This is It's Mr. Potato Head, right? I mean, we could do it with Silly Putty as well. Fail. That's right. We really failed the toy recognition test. So the idea here is, Frankenberg says you have something like an inventory of constitutional commodities, right? You take these constitutional elements, they're decontextualized, they're uploaded to this global inventory. Then when constitution makers reach in and they pull out the parts they need. What do I need now? I need a preamble. Now what do I need? I need something about the legislature. Now I need something about the executive. Now I need something about the judiciary. Now I need something maybe or not about federalism. That's an optional piece. So I need a set of eyes, I need a nose, I need a mouth. Glasses for Mr. Potato Head are like federalism. You might or might put them on. You need some sort of an amendment procedure. And so these parts can be mixed and matched more or less at random, right? And the result you get is the modern Constitution. Slightly different view, right, starts from the premise that yes, Constitution makers, and I call this the competing models approach, Constitution makers do have a common set of elements that they can choose from, like a box of Lego bricks, right? So I think of bricolage as the Mr. Potato Head model, and I think of competing models as the Lego model. So you start with this box of bricks, and you can build things from the same box of bricks that everyone else has access to, right? In an age of globalization, we all understand we have easy access, easier than ever, access to how constitutions elsewhere are written, easy access to the literature on constitutionalism in other countries. So what do we do with this wealth of information, this giant box of Lego bricks at our disposal? So the competing models thesis would be that rather than simply randomly picking a set of eyes, randomly picking a nose, randomly picking a mouth for comic effect, isn't that funny? Instead, people tend to pick from this box pieces that go together, and they have something in mind when they're building their constitution, right? Now, if you pick the shark and the cannons and the sails, you could slap those on top of a spaceship, but generally speaking, constitution makers don't do that. Even though everyone has access to the same set of building blocks, ultimately these constitutions are constructed with particular models in mind, models in which the pieces tend to go together in some functional, thematic, ideological, or historical, intellectual sense, right? So likewise, when you shop at IKEA, whereas Frankenberg argues that you would go through and simply pick a sofa and pick a chair and pick a desk and just throw them into your living room, the other way of thinking of it is people don't do that at random. They have, oh, I like this particular showroom. I like this particular line of furnishings. Obviously, it doesn't work to have the classic dark mahogany bed with the sleek glass and steel coffee table. So constitution writing may be the same way. You have access to all of those parts, but you don't do the constitutional equivalent of put the dark mahogany bed with the glass and steel coffee table. Right? Those are competing models, just as they're competing models of how to furnish a home, they're competing models of how to write a constitution. Now, to investigate these theses, these competing theses, I do an empirical analysis of preambles. Why study preambles? So, on the one hand, they are supposedly the most varied, non-standard part of a constitution. Because they are said to express national identity and national values. They are the part of the Constitution where framers can let their creative fancy fly free. They're unconstrained, often from considerations of judicial enforceability. And so you really get to write what you think, and you get to make something for your country, right? You're free from the burden of functional considerations. So therefore, preambles ought to pose an especially demanding test of the notion that constitutional drafting is standardized or formulaic. They should be very unique, very idiosyncratic. In previous work, I've looked at bills of rights and concluded that there are two basic ways of writing a bill of rights. There's a liberal way and a statist way, and there's a way that's more comprehensive and there's a way that's less comprehensive. And the reaction of that scholarship has been, okay, but that's just bills of rights. There are other parts of the constitutions that are not as standardized. It's just bills of rights that are standardized. And my response to that has been, well, tell me what isn't standardized. And the response is preambles. Preambles are very varied and idiosyncratic. Okay, so let's look at preambles. The challenge has been accepted. Now, why are preambles difficult to study empirically? Because they are so varied, it is difficult to devise an appropriate coding scheme for turning them into quantitative data. Coding meaning a way of taking these texts and turning them into data that can be analyzed, making them numeric in a way. So, for example, if you're analyzing a Bill of Rights, you can quite easily say to yourself, well, does this Constitution contain a right of assembly? Does this Constitution contain a right of free speech? Does this Constitution contain a right to health care, a right to education, and so on and so forth? And you could argue over how those categories should be defined and how many there should be. But those are yes-no questions. Those can be reduced to a 0-1 format. And once you can reduce a document to a series of zeros and ones, or zeros, ones, and twos, then it's amenable to a range of empirical analytical techniques. The problem is that preambles are so varied that it's really hard to tell what kind of coding scheme, if any, would be appropriate. In order to know how to code preambles, you'd already have to know how to code preambles. More generally, it's hard to look for patterns across a large corpus of text, which is what we're doing, if we aren't even sure exactly what patterns we should be looking for. So when I say preambles are varied, I'm not asking you to take my word for it. Let's look at some examples. Example one, granted bias match, I've redacted parts to make it a little more challenging. So the game here, I'm going to give you 3 examples, and let's see if anyone can tell me what countries these are from. This is the preamble of country X. The 4th day of November 1, yada, 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 formalistic stuff about amended in accordance with the law on diverse dates. This just year 1000, blah, 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 and revised in accordance with Law Consolidation Act, 31st day of December 1988. All right. Any guesses? Any guess about what kind of, can we narrow this down? Let's play animal, vegetable, mineral with this, right? So there are roughly 200 countries in the world. Let's start to narrow it down. What do we know about this country, probably, by looking at the preamble? Yeah, well, it feels British. It feels common law-ish, right? This is probably not Germany. It's probably not France. It's probably not North Korea. Probably not Iran, right? Probably not the People's Republic of China. Anything else? What else could we guess? Yeah, it feels like a constitutional monarchy. And does this feel like, given it's a constitutional monarchy, do we think this is a young country or an old country? Young constitution or old constitution? So, no, you can all write down your guesses, and I'll move on to example number 2. Give you time to write down your guesses. Example number 2 feels very different, and this begins to show why it's difficult to code preambles because they're so varied. In the course of their millennia-old history, the blank people working diligently, creatively, and fighting courageously to build their country and defend it have forged a tradition of unity, humanity, uprightness, perseverance, and dominance. Let's go down here. People of all nationalities, uninterrupted struggle, socialist countries, resounding exploits, campaigns emerge victorious, wars of aggression, colonialists, imperialists, liberated, reunified, fatherland, completion, national democratic revolution. This is a different kind of country, right? Anyone want to make some claims about what kind of country we're probably looking at? Are we looking at the same kind as country as example 1? No, this feels pretty different. What are we probably looking at here? Yeah, this is probably some kind of a socialist country. Do we think this country is 200 years old, or at least the current regime? Probably not older than Marx if it's socialist, right? So, you know, we've got a lower bound on how old, an upper bound on how old this country can be. So it's a newer country. So again, feel free to write down your guess as to what country this is. And finally, I think this is the hardest. Whereas the people of blank have affirmed that their nation is founded upon principles that acknowledge the fatherhood and supremacy of God and man's duties toward his fellow man, firmly believe in the dignity of human values, express their respect for the rule of law, ideal of free men, freedom, enjoy economic, social, and political, civil, and cultural rights, Constitution will reflect these principles and beliefs, high ideals, nation, fundamental rights, freedoms, yada, 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 right? Cut, paste, boilerplate. Right? What is distinct? This is about as distinctive as oatmeal, right? This is the constitutional equivalent of hamburger helper. You can put this language in any constitution and it fits right in, right? This is a generic sounding preamble. This one should be especially difficult to identify. Right? Any guesses as to what? Oh no, I blanked out my notes. This is the preamble to. Oh, I remember. Okay, good. So this was Tonga. Anyone have Tonga? No. Okay, that's fine. This was Vietnam. Anyone in Vietnam? Anybody have, so there are these smaller sort of island nation states, and a fairly small crew of people helped them with their constitutional consulting, including Yash Ghai, the previous holder of the YK Pao chair, did a fair amount of this kind of work. They don't have a lot of infrastructure for writing their own constitutions, and or their constitutions are written with a lot of help of international consultants or even directly by the international community, and they copy extensively from each other. Does not help. I mean, partly because they are small and they don't have a big native long constitutional culture tradition or infrastructure for writing something original. So this is Grenada. This is Grenada's 1973 constitution, right? Also common law jurisdiction, but doesn't read as common law-ish as the Tongan constitution. The Tongan constitution Tonga actually is one of the world's oldest constitutions, and Grenada this is the 1973 Constitution of Grenada, so we're also seeing a time effect. Okay. So how do we analyze these things that are so varied, right? Very difficult to see. We can see what a rights checklist would look like, but what on earth would a preamble checklist look like, right? We know that there are obvious differences in genre, and these are just reeking with different kinds of ideological language. But that's very difficult to code, to say to a research assistant, if you see this, write down the number 0. If you see that, write down the number 1. Even if you try to do that, you're probably not going to capture all the relevant aspects of variation. So here comes the structural topic model to the rescue. This is a software package that can be downloaded and installed for free with an R, which is also free. And here is what I mean, but here is what is meant in the literature by topic, right? A topic is a set of words that tend to appear in conjunction with one another, right? To be really technical, it's a probability distribution over words. So take two topics, right? One topic, the word spades will appear with, say, 70% probability. The word bridge will appear with, say, 65% probability. And the word Trump will appear with 80% probability. Then we have a different topic in a conversation. The word primary appears maybe with 90% probability. The word poll appears with 50% probability. And the word Trump appears with 80% probability, right? Now, these are different topics of conversation. Right? If you see that first set of words co-occurring, you're probably talking about some sort of a card game. People are talking about card games. If you see that second set of words, even though there's a word of overlap, Trump, you're probably talking about the American presidential election process, right? Primaries, polls, and Trump. And what's interesting about the structural topic model is because it's looking for patterns of word co-occurrence, it is not fooled by the fact that Trump appears in both topics. It realizes that Trump has a high probability, that word is quite distinctive, but also has a high probability of occurring across two very different unconnected topics. And so in deciding whether a particular text is about topic A or topic B, the software will look to see what other words appear with the word Trump. Okay. So the structural topic model goes through your documents. It analyzes all the documents to identify the word distribution associated with each topic. So it might come up with these two topics, topic A and topic B. It then can measure the prevalence of each topic within each document. How much of this document is topic A? How much of this document is topic B? And those are your topic prevalence measures. Right? Okay. So how many topics, if we run this magic on preambles, how many topics, distinctive patterns of co-occurring words, how many topics do preambles contain? Very surprisingly, the structural topic model, the diagnostic suggests that the preambles break down into just 3 topics. Now, this should be surprising for empirical scholars because if you think about how models work, generally speaking, the more variables you put in a model, the better you're able to predict whatever it is you're trying to predict, right? So in this case, what we're trying to predict in a sense is the breakdown of words, the composition of words in this document. And so you intuitively and methodologically, the more topics you have, the better the fit the model should give you. What's really surprising is that 2 of the major diagnostics suggest that there are really no more than 10 topics. If you try to push it to 10, the model gets significantly worse very quickly. And the held out likelihood measure, without getting too technical, suggests really that 3 is the appropriate number. So this is a very low dimensional model. And the held out likelihood measure suggests that if you try to model preambles as a composition of more than 3 topics, the model just gets worse and worse. It does a worse job of explaining what you're seeing in the preambles. So the next question is, what are these topics? Right? Structural topic model, content analysis is not a substitute for interpretation. Right? What it does is it goes through the entire haystack for you, reports every object it finds in the haystack, and then you decide what you're looking for. If it's needles, you find the needles and what the computer's found for you. So the resulting topics from the structural model, we can think of these as topics or ideological vocabularies. Each topic that the STM identifies has distinctive historical, legal, and above all, ideological characteristics. Here's what I mean. Here's topic 1. Let's just take a look at these words here. And you may find that this corresponds to the type of preamble we saw with Tonga. Shall assemble Parliament. England is actually in there. Lord, Britain, Commonwealth, Court, Judiciary, whereas, Council, right, King, Subject. Okay? So just hold that in your head. That's one of the topics that STM identifies. Holding that in your head, now let's look at the next topic. Again, some of this may be hard to see, but we see words like Arab, China, socialist, African, homeland, progress, struggle, revolution, socialist, Islam. These words are deliberately truncated because the text pre-processing tries to take off suffixes because you don't want constitution and constitutions to be identified as two different words, right? Different feel here, right? This feels more like the Vietnam kind of preamble, right? So far we're seeing maybe those three preambles we looked at, they differ a lot, but they may be representative of genres, ideological genres of constitution writing. Now let's take a look at the third topic. What's distinctive about this topic? Human, peace, dignity, govern, principle, protect, fundamental, state, nation, justice, constitution, freedom, right, people. Again, generic, hamburger helper. And that's an overly American cultural reference, isn't it? Or North American. I don't know what the Cantonese equivalent of hamburger helper is. Oh, never mind. Sorry. Is there an equivalent? All right, it doesn't matter. So, oatmeal, pablum, generic stuff, right? This reads like I took a bunch of constitutions, a bunch of international human rights or international legal documents, put them in a blender, hit puree, and just squeezed it out in a tube on someone's constitution, right? If we look closer, we might see some things that are kind of somewhat interesting. Here's what we see. We see the word world, we see universal, we see charter, and we see African. Okay. Now, charter and African are tricky words, right? Both of those words could refer either to domestic legal instruments or something that is very specific to a particular region. Domestic charter, the African people, the African homeland, or they could refer to international norms and international documents. So the European Charter of Human Rights, European Convention, the African Charter of Rights and Freedoms, the UN Charter could be part of UN Charter. African could be part of African Union. It could be part of a reference to regional organizations, the Economic Organization of West African States. So these are ambiguous words. Like the word Trump, these words are distinctive, but they could appear across multiple topics. So let's take a look at how these words are used in documents that are heavy on topic 3 and documents that are heavy on topic 2, right? So we've got, I'm calling topic 1, I'm calling this a liberal archetype. I'm calling topic 2 a statist archetype. And I'm calling topic 3 a universalist archetype. Are these labels accurate? Well, let's take a look at how the word charter and African these words are used in documents with a high prevalence of topic 3. If topic 3 is highly prevalent, then overwhelmingly the word charter is used to refer to the UN Charter or some other international charter. The word African is overwhelmingly used to refer to the African Charter or the Charter of the Organization of African Unity, and only about 13% of the time is the word charter being used to refer to a domestic instrument. For preambles that STM identifies as having a below average universalism score, the vast majority of the time, 75% of the time, the word charter is being used to refer to a domestic legal instrument. So not only is STM sorting words into topics, but when the same word appears across multiple topics or is being used in different ways, it knows how the word is being used. Because, again, it's looking at the other words that the word charter is being used with. So the measures of topic prevalence are really a proxy, the measures of prevalence of topic 3 in particular are really a proxy for not just generic constitutional language, but language that is very internationalized. Indeed, language that may be even taken from international legal instruments. And as we'll see in a moment, we'll see that constitutional preambles that score high on topic 3 bear a strong linguistic similarity to international human rights instruments. So there is this process of mutual influence and interdependence between international law and this style of constitution writing. Right? Topic 1, the liberal model, what I call the liberal archetype. These kinds of preambles belong disproportionately to countries from a common law tradition, and the words that they contain are very commonwealthy, very common law. The word clouds I showed you earlier, the size of the words corresponded simply to the raw probability of the word appearing, but that means words like constitution feature very prominently, and that's not a very distinctive word. What's more interesting are words that have a combination of frequency and exclusivity. They appear a lot within the topic, but they also tend to appear only within that topic. If you look at topic 1, the high frequency exclusivity words, frex, are act, parliament, kingdom, commonwealth, lord, amend, majesty. Wow, that flavor is pretty clear, right? Topic 2, socialist China movement regime, construct, continue, and cause. Again, a very different flavor. Topic 3, generic, men acknowledge individual recognition, recognize, inherent, and pledge, right? So the topic 1, constitutions that score high on topic 1 overwhelmingly belong to common law countries. Constitutions that score high on topic 2, what I call the statist archetype, they're written in the statist archetype, belong disproportionately to the civil law countries. And the constitutions written with a lot of topic 3, the universalist topic, contain language that we find in international law and international legal instruments. So notice that you have not just 3 genres of constitution writing, but each genre of constitution writing has a symbiotic relationship with a different legal tradition. These constitutional traditions don't exist in these ways of constitution writing don't exist in isolation or in the abstract, but rather they exist in the context of some other body of law, common law, civil law, and in the case of constitutional law, international law. So the usual typology of comparative law, which says we can divide the world into the civil and common law families, is inadequate. It's inadequate because it does not capture the tremendous influence of international law on constitutional law. By introducing a third model of constitution writing, what I call the universalist archetype, we capture the commingling and interdependence of constitutional law and international law. So if we were to speak of legal families, in private law, perhaps we could speak of just civil law and common law. When we speak of constitutional families, we'd have to say there are 3 families. There's a liberal or common law family, there's a statist or civil law family, and there's also a universalist or international law family. Again, characteristics associated with each type of preamble ideology. If you have a lot of topic 1, these are common law countries, countries with a lot of negative rights, civil and political rights, and an emphasis on judicial protection of the individual from the state and the judicial enforcement of constitutional limits against the state. If we look at countries with preambles that score high on topic 2, these are civil law countries, statistically speaking. They are countries with a more statist rights catalog, a lot of positive rights, social and economic rights, and moreover, citizens aren't just rights bearers, but have duties and obligations to help the state achieve its collective goals. If we look at countries that score high on topic 3, universalist archetype, these tend to be smaller countries and poorer countries. These are countries with constitutions that explicitly give privileged treatment to treaties and international law, right? Again, the relationship here in Model 3 between constitutional and international law, and strong textual similarity to international legal instruments. So in the full version of the paper, and these slides will be available, I understand, on the website. Here's a list of the 10 most liberal preambles: UK, Australia, Tonga, Brunei, New Zealand, Jordan, Canada, Liechtenstein, Thailand, and Samoa. Overwhelmingly common law. And Liechtenstein's only in there because it's got a 1-sentence preamble. So the reliability of that, there's a high standard error on that particular estimate, right? Thailand is at least a monarchy. So these are common law and or monarchical countries, overwhelmingly, okay? Statist preambles, no surprises. China, North Korea, Vietnam, Cuba, Iran, Laos, Myanmar, Cape Verde, Timor-Leste, Sao Tome and Principe. So STM, what's interesting is, even if you're skeptical of whether this methodology can tell us anything real about the real world, it is doing a good job of sorting countries into categories that feel pretty real. These categories correspond to something. I mean, these category 2 countries are definitely different from the category 1 countries. And we can get at this through just the way in which they write their constitutional preambles. The preambles, even if the preamble is not the soul of the nation, and it's at least a window into the soul of the nation, it would seem. And finally, universalist preambles. This is interesting. We've got here a mixture of very small island countries, post-Soviet countries, and international legal documents. The ICCPR and the ICSCR, linguistically, the model is saying the preambles to those documents are almost identical, really look like the preambles to the constitutions of this category. And if you think about, so you've got these small island countries, you've also got countries where the international community has played a direct or indirect role in reconstructing their constitution. And these post-Soviet countries where statism, communism, has been discredited, but it makes no sense at all for them to jump into the common law tradition. That's bizarre and very alien. So what do? They pick something anodyne, universalistic, internationally acceptable, and that's this international or universalist archetype. So, last slide, initial conclusions from this project, which again I'm building out into a book, so I welcome the input. Constitution writing is standardized, but it isn't standardized into one standard. There are competing standards, competing ways of writing constitutions. So the convergence literature the idea of convergence is incorrect, but so too is the idea of endless fragmentation. What we have is competing standards or models, each with distinctive ideological, historical, and legal characteristics, and a universalist model that is heavily influenced by international law and thus generic looking is gaining ground. And the rise of this universalist model mirrors the growing scope and influence of international law and institutions in the post-World War II era, which dovetails nicely with what we see in the literature about the transformation of international law since World War II. So I hope I've left enough time for questions. Thank you for your patience, and I hope that was coherent.
Thank you very much. Any questions from the floor? Yes, Albert.
I have two questions. One is a technical one about the words in the topic. Maybe I didn't listen very carefully. So, for example, for topic A, what you call the liberal archetype, where do the words constituting topic A come from? Do you select the words, or does the computer program select the words constituting a particular topic?
The software selects the words. I don't know why we've lost the PowerPoint.
Just try to, yeah.
Okay. So I'll try and do a show and tell these, but in the meantime, the software, this is what's great about the structural topic model. I don't tell the computer which words are important or distinctive. The software picks out the words that tend to occur together and form coherent, self-contained topics. That's entirely driven by the software. So now one might say, well, what does the software add to our understanding of preambles that I can't do simply by reading the preambles myself? I can do that. I mean, I can read 200 preambles and give you my impression, as one would have gathered from those three examples I gave you, Grenada, Tonga, and Vietnam. I could say, I think that there are three different genres out there. Problem with just doing it impressionistically and not using the software is, first, I don't know if those are representative, right? This is my judgment. I'm kind of like, I think that, these are recurring constitutional archetypes. And second, I might be able to identify pure examples of each type, but I don't really have a systematic way of taking a hybrid preamble, and most preambles contain a mixture of universalism and statist content, or universalism and common law content. I don't have a way of quantitatively measuring with any degree of exactness the breakdown, right? So what's interesting is, for example, the German constitution. On the one hand, Germany has a strong statist civil law tradition. On the other hand, obviously following World War II, it had to incorporate international norms. The same with the Japanese constitution. And the nice thing about the model here is it says, when I look at the German or Japanese preambles, I see an almost 50-50 mix of statist and universalist elements. And moreover, I haven't done the time series analysis yet, but I'm almost convinced, I'm quite sure that what I'll find is that Germany and Japan are among the first constitutional preambles to incorporate this type of language, because they are among the first to be bent to the post-war international legal order. But I mean, sorry, Albert, that's a very long way of answering your question. I let the software do it, and I think that there are advantages to letting the software do it, because then you don't have to take my word for it that these are real, naturally occurring phenomena.
So do you mean that for each preamble, so do you mean that each preamble is one document for the purpose of the operation?
Yes.
And you only choose the number of topics, is that right?
Yes, and I don't choose the number of topics at random either. There are tests that I run basically to test the predictive power of models with different numbers of topics. So I can see, for example, if I have a 20-topic model, how good is the model at breaking the preambles down, explaining the variance? If I have a 2-topic model, how good is the model? And I can run these diagnostic tests for models with different numbers of topics. And when I do that, it says different tests tell me you're looking for a number somewhere between 3 and 10. And one of the tests in particular says it's really just 3 topics. When I try looking at models with more topics, the topics do not lend themselves to natural interpretation. They don't really make a lot of sense. One starts to see things that really feel like one topic split into multiple topics. So a combination of human interpretation and some of the diagnostic tests say, really, 3 topics is the right number.
So what you tell the program is that please analyze this document using 3 topics.
That's right.
And then the topics which you call A, B, and C come up.
Yeah, or rather, I mean, just to be a little more precise, what I say is take all 200 preambles and analyze all 200 of them for their relative mix of A, B, and C, but give me measures that are specific to each document. And moreover, when the topics are being identified, the software pools together all of the preambles, right, and tries to estimate across all of them what the right 3 topics should be.
Oh, so the 3 topics A, B, and C, they are produced by the program going through all the preambles as if they were one document, is that right?
Yeah, yes, that's right, more or less.
Yes, and then for each document or each preamble, the program also analyzes how much percentage is devoted to each of the 3 topics.
Right.
Right. Okay, thank you. So that's my technical question. Only one more question with substantive question about this civil law family. You say that topic 2, that is what you call the statist archetype, is associated with the civil law family.
Statistically correlated, right?
But from the list of the most statist preambles, it seems that many of the countries are the communist or socialist countries. So, so will there be some? I mean, what's the relationship between civil law and socialist or communist? For example, as you said, Germany or Japan or many European countries, they are civil law but not socialist or communist.
So, if we were to go further down the list, we would see a lot of civil law countries, and we wouldn't see many common law countries. So that's one part of the answer. But the other part of the answer is that if you want to find specimens of constitutional preambles that are almost purely statist, they tend to be undemocratic regimes. And I think what's happening here is, if you are China or North Korea or Vietnam, one of the constitutional literature doesn't say much about this, but constitutions are really profoundly ideological. Constitution writing is a profoundly ideological act. And it is even more, you are really trying to justify the existence and organization of the state to a wide range of audiences, both domestic and international. And people say, well, no, constitutions are about constraining this power of the state and organizing the state. They're not about explaining or rationalizing or justifying. But there are a lot of constitutions in the world that aren't really that effective in the sense that they aren't complied with. And in those cases, if the constitution serves any function at all, it is this expressive, ideological, rationalizing, justificatory function. So sham constitutions, what I could call them, are even more ideological in function than, say, the constitution of Germany or France, right? So to perform this justificatory function, they have to tell some sort of story that is acceptable to the audiences they're communicating with. Now, Portugal has a relatively statist constitution. It's not in the top 10, but it's one of the most statist. And let's say you're China, and you're writing something, or that's too close to home, literally. Let's take North Korea. You're trying to write something that is acceptable to a wide range of audiences. Now, you could write something that says, all power resides in the supreme leader. I take everything that I want, and you all live in poverty and despair, and we're a rogue state, and we bully, and we're basically an organized mob in the form of a state. I could say that. That's not acceptable. All right, what are my other choices? Well, what's proven acceptable? I could write something about Her Majesty and the year 1800, and no, that's not going to work. That is bizarre. That's That's an off-the-shelf option, but that doesn't fit at all. And what I'm saying here is off-the-shelf options are by definition higher legitimacy because they're already accepted and established. So what does that leave me with? Well, I could go the sort of United Nations international human rights-y language, but that's exactly what we don't do. So what can I reach for? Well, how about something that celebrates the state as the personification of a political community? And if the state speaks for the community, then anything that stops the state from doing what it wants to do is something that stands in the way of the community getting what it wants. And so this kind of ideological narrative is more suitable to justifying the unlimited exercise of state power, right? So the most easily reappropriated type of conventional ideological narrative is the statist narrative. That's not to say that all countries with a statist narrative are authoritarian, totalitarian regimes. It is to say that this type of narrative, it's easier for North Korea to borrow from Portugal than it is for North Korea to borrow from the UK or to borrow from Grenada or the International Civil and Political Rights Covenant. Does that make sense?
Yes.
Through automated pattern recognition, you have arrived at the three types of constitutions. Now, I'm sure you're familiar with types of nationalism or varieties of capitalism. So, Professor Law, have you relate the result of your research with the varieties of capitalism approach of Holland Soskets? There is the liberal economy, or the types of nationalism by Leah Greenfield. There is individualist and collectivist. So how do you see the implications on interpretation of results in the broader political science literature?
So I have not looked at varieties of capitalism, which could be an interesting thing to do. The closest that I've done is to look at strains of constitutional writing among different types of authoritarian regimes. I've looked at, my co-author Neil and I looked at the difference in constitutional writing between regimes that are authoritarian regimes that are monarchical, ones that are religious, ones that are organized around a party or a particular leader, and I'm missing one. Anyway, different types of authoritarian regimes. And it turns out that different types of authoritarian regimes employ different types of constitutional writing strategies. But that's a completely separate project that doesn't use STM as a methodology. That's just hand-coding of bills of rights.
Eric and then Simon. Eric first. Yeah.
Thank you, David, for your inspiring presentation. I've got one minor comment and one short question. I noticed that you included the UK in your analysis and you used the preamble of the Human Rights Act as a text to be studied, but since the UK has an uncodified constitution, you may want to include also the preambles of the Constitutional Reform Acts of 2005, the Constitutional Reform and Governance Act 2010, and also the European Communities Act 1972.
Those are in there.
Yeah, those are in there.
Along with the Act of Settlement, Magna Carta, the Habeas Corpus Acts, Bills of Rights Acts. The UK preamble goes on for quite a long time.
But I guess you can limit your study to post-war preambles.
No, we went all the way back. Why not? I went all the way back.
Okay. So my question is, do constitutional preambles generally reflect the content of constitutional provisions? Perhaps you can spill some ink on the overall coherence of preamble and text from a comparative perspective, because
yes,
the Hong Kong Basic Law strikes me as an odd man out. It has a very statist preamble, but yes, fairly liberal provisions.
Yes, the Hong Kong, yes, that is right. The Hong Kong Basic Law is a thorn in my side because of the disjoint between the way in which the preamble is written and the way in which the codable parts. That you were absolutely right. And this is exactly, it is fair game to bring up this exception. Of course, this is empirical work, and so these are generalizations, and there are going to be some exceptions, and Hong Kong is an exception. Statistically speaking, so I have these ideology scores. The two things that I've coded and analyzed empirically now are preambles using this methodology and bills of rights using a more traditional coding typology. And generally speaking, they're strongly correlated. So if you have a liberal Bill of Rights, you have a liberal preamble. If you have a statist Bill of Rights, you have a statist preamble, and vice versa. Hong Kong is one of the reasons why the correlation is not perfect.
Okay, thanks, David. My two questions sort of parallel Eric's questions. So they're both methodological, and I just wanted to ask you, how did you deal with the situation where countries have changed their constitution or amended the preamble? Did you sort of just collapse it all together and said that that's the preamble for that country? Because potentially, that seems to be the way one would do it with coding, but one might be sort of missing some important subtleties there that are temporal, and which could be important. So I'm just curious about how you dealt with that. Yep. The second question is sort of echoing the second question that Eric had, which is your title of your paper is Constitutional Archetypes, but is it more accurate to title it Constitutional Preamble Archetypes? Because are you proposing, or have you done, or are you proposing to also make reference to the rest of the body of the Constitution, code it, and then to check your initial archetypal classification? Good, yeah. So I think both good questions, and what order should I take them in? Let me take the first one. So this analysis just looks at preambles as of 2012. I'm currently filling in time series going back to just before the outbreak of the First World War, and I'm going to have 5 intervals: pre-World War I, pre-World War II, immediate post-World War II, height of the Cold War, and then bring it up to 2014. So I'll be able to make some claims about so what you're seeing, for example, is for the construction of the UK's total constitutional preamble as of the year 2012. That's what's analyzed. With respect to whether I can say that these are constitutional archetypes, I mean, in a literal sense they are, because they're archetypes in their constitutional nature, although they don't speak to the entire Constitution based on the findings here. But the more satisfying substantive answer would be, I've already started to do these correlational analyses, and as I mentioned to Eric, the Bills of Rights line up pretty well with the preambles, and that's nice, right? Good that they do line up. And there are some really interesting correlations. This is why I say these archetypes are multidimensional. They're not just ideological. Well, maybe they are, maybe they aren't. I mean, for example, take some things that the constitution writing literature just treats as optional or esoteric. For instance, does your constitution name the national capital? Does it name or identify the national flag? Now, these are not inherently ideological things in a sense, because every country has a flag and every country has a capital, and it would seem to be a matter of pure preference whether you happen to specify that in the Constitution. No harm, no foul either way. Now, it turns out that they're strongly correlated. Those two types of provisions are strongly correlated with the ideology of the preamble, or the so-called just the preamble ideology. There are a couple possible reasons for that. One is that, again, Constitution drafters are using models. When they take 3 pieces from a model, they're going to take more pieces from the model. It may be because they're lazy, it may be because they think the pieces go together, but there's not we don't see a lot of random and mixing and matching. They don't write the Mr. Potato Head way. They write the Lego spaceship or pirate ship way. They're going to build a spaceship or a pirate ship. They're not going to build half a spaceship and half a pirate ship and plunk them together. Excuse me. The other explanation is simply that actually we're overly narrowly understanding what it means to be ideological. If you're writing in the statist vein, a constitution, right, the legitimacy and authority of the state are predicated upon the notion that the state speaks for, acts for, embodies a particular political community. And if that's the ideological premise, then you have to be relatively preoccupied as well. You then have to be attentive to the identity of the community for which you purport to speak, the membership of the community for which you purport to speak, and the symbols of the community for which you purport to speak. If the legitimacy of the state and the exercise of state power are predicated upon the state's identity with the community, the Irish people, the Jewish people, right, the Korean people, Juche, right, then you have to construct that as part of your constitutional narrative. And
invoking things like the flag and the national capital. These are symbols of nationhood. So I don't think it's coincidental, pure coincidence, that constitutions with statist preambles also go out of their way to identify symbols of statehood, because the kind of narrative that they're offering is different from the kind of narrative that a liberal preamble offers. A liberal preamble says to you, we just accept traditional forms of authority. It could be monarchical, it could be religious. That's not really the modern claim to legitimacy on which the state is predicated. What it's predicated on is we're going to give you a state that operates within constitutional limits. So the legitimacy of the state derives not from the nature of the community for which the state speaks or the pedigree of the state's authority. It derives instead from respect for constitutional limits. So the liberal archetype actually almost thrives on being paired with some illegitimate, historical, holdover, monarchical, religious type of authority. Because if you have that kind of authority, you don't want to repudiate it. The way to make it legitimate is to slap some constitutional limits on top of it. Whereas the statist archetype, you're not dealing with an illegitimate form of authority that you're trying to legitimate. You're trying to construct a legitimate form of authority in the first place. And you're trying to tell a story about who we the people are, right? What is the polity for which the state acts? And I know that's a lot of theory speak, but that is all a very long way of saying that there are a lot of correlations between the quote-unquote archetype ideology and other choices throughout the Constitution. Some things aren't correlated, like federalism. There's no ideological correlation. I've looked, I can't find one, probably because there are strong functional reasons to be federal or not federal. Other things like legislative immunity turn out they are correlated. So too is presidential versus parliamentarism. So too is national flag, national anthem, national capital. Sorry, I took too long for that one.
Jiangnan, and then, yeah.
I think your mic might be off.
Okay, so the structural topic model, I wonder if there is a word limit to analyze, because constitutional preambles, that's pretty long, but for my research, like mainly I'm interested in online comments. Usually those are very short. So I wonder if those are possible to be analyzed using this model. And another question is, I wonder if you do you worry about losing information during this language translation? Because I would assume that eventually you need to translate all those preambles into English, right, to analyze. So do you worry about losing some information in this process of translation? And also, I think it's probably not a big problem for English for this kind of analysis, but for Chinese, so sometimes it's a like 3-character or 4-character word, yeah. And computer might automatically trunk them into 2 separate words and then lead to misunderstanding. So how to deal with this problem? Thank you very much.
Thank you, Diana. I'm looking at the clock. I see that there are 2 more hands. Norbert and is it? There was one more hand here. Okay, just Norbert. Maybe I'll take, and Kai. So maybe I'll take Norbert and Kai's questions as well, and then you'll answer all of them in one go. Yes, Norbert, please.
Thank you. I have 3 questions, but I would probably talk about just 2. The first question is about the use of unigrams. So in your analysis, you're using unigrams, but have you thought about using bigrams and trigrams to try to see whether the collocations lead to different topic analysis results as you change the way you define the tokens? So you differently tokenize, yes, Sure. And also, I'm wondering whether I'm not familiar with constitutional language, but this kind of work may call upon the use of different features that are particular to the language domain. For example, we talk about how to differentiate classical epics, whether they're based on true stories or pure imagination. And the way they do it is try to see the network structure of the characters in the epics. So apparently those that are based on true stories, the relationships between the characters present some kind of associative pattern in network structure. Whereas those that are based on imagination, they're fiction, they present a dissociative kind of network pattern. So that's particular to, of course, that kind of language domain. I wonder if the constitutional language may also present something like that, so as to assist your work going beyond just features of the texts. Another question is about the in the beginning of your presentation, you talk about the possibility of studying diffusion pattern dynamics from constitution to constitution. How does your current work inform us on that particular question, and whether we can look into is there a way for how would you approach that question given your future your plans to have a time series kind of a study of this? Thank you.
Thank you. And finally, Kai.
Thanks. I also have only 2 points. The first is a question of history. I think this touched on your idea about having a time series. I think that it would be very fascinating to see actually how the proportions of the statist, universalists actually changed over time. The second question is about wondering whether you can force STM. You can't. To just you force the model to give you 4 topics as a matter of trying to see whether there's a fantastic 4th archetype that actually comes out from the analysis. Maybe there's nothing, but even if there's nothing, it's a good possible to show that 3 is sensible.
Sure. I'll take those very quickly in reverse order. I did try to look at 5, 7, 10 topic models, and none of the other models had compelling topics that lent themselves to substantive interpretation. I totally agree with your argument. That's exactly why I'm collecting the time series data. I already think I'm going to see universalism march upward. I don't see how it could be otherwise. Norbert, unigrams, bigrams, trigrams, haven't tried them. I'm actually waiting on KMI at Princeton to finish the algorithms he's working on, which will relax the bag of word assumptions altogether, so then I don't have to assume a bigram or a trigram or a unigram structure of the data. Not sure I'm very interested to hear more from you at some other venue about this idea of language domains and language structures are specific to particular domains. This is an entirely new concept to me. I'd love to hear more about the diffusion dynamics. That's what I think that I'm studying, but causal claims are almost impossible to make. And you know what kind of data we're working with, right? And then Zhengnan, let's see, the word limit. No, you can analyze much longer documents. It's just a more complicated multi-step procedure where you can't put them all in a spreadsheet. It's just a minor thing. Well, for me, it's major, but for someone who knows what they're doing, it's a minor problem. The other languages, the Chinese issue, that's a problem. And again, this is a question of combination of computing power and algorithmic development. I mean, we're a year or 2 away from the point where we no longer have to make this isolated. The bag of words assumption is the assumption that the word order doesn't matter, and you can rearrange characters at random and they don't form units, which is problematic, of course, with Chinese for the reasons you point out. But I think what's interesting is that even with these limitations, right, as long as we're asking the right kind of question, and I think this is the right kind of question for this methodology, even within the limits of this methodology, the topics that are identified really are kind of coherent and lend themselves naturally to interpretation. My belief is that even with a more sophisticated method that relaxed the bag of words assumption, we'd only get better, even clearer results.
Thank you very much. Thanks so much for your participation and the excellent comments and questions. Please join me in thanking David for your stimulating and refreshing ideas. Thank you so much. Thank you.
Thank you. It's a great honor to be here. Thank you.